stipulated by the Constitution. We do not have a federal government police force. We have the Nigerian police force, which shall be administered, organized, and supervised by the Nigerian police force.
No, my lord, I want to say something. I want to say something here. Perhaps it might also enlarge the scope of people who should be invited here for examination. My lord, if we cannot find those who literally murdered Abiola, who are those people who could be said to be the beneficiaries of the death of Abiola?
Rogers has linked you with some of the killings he did.
He never did.
He linked you with the attempted murder of Hebrew.
He did not.
My lord, the matters council is leading the evidence in our matters.
Is this an adversary proceeding?
It's not, my lord, but we can't be talking about cases which are in court,
Is
my
this
lord.
an adversary proceeding?
It's not, my lord. These cases are in court, my lord. I'm just reminding your lordship.
My lord, sorry, my lord, I think I'll be in cross-examination.
Legally Speaking, a program that deals with legal issues and questions we face as citizens of this amazing country, Nigeria. Legally.
The Nigerian police force, which is the only one allowed by grossly abused. Our governors have to share police powers with the president as stipulated by the Constitution. We do not have a federal government police force. We have the Nigerian police force, which shall be administered, organized, and supervised by the Nigerian police force.
No, my lord, I want to say something. I want to say something here. Perhaps it might also enlarge the scope of people who should be invited here for examination. My lord, if we cannot find those who literally murdered Abiola, who are those people who could be said to be the beneficiaries of the death of Abiola?
Rogers has linked you with some of the killings he did.
He never did.
He linked you with the attempted murder of Hebrew.
He did not.
My lord, the matters council is leading the evidence in our matters.
Is this an adversary proceeding?
It's not, my lord, but we can't be talking about cases which are in court,
Is
my lord.
this an adversary proceeding?
It's not, my lord. These cases are in court, my lord. I'm just reminding your lordship.
My lord, sorry, my lord, I think I'll be in cross-examination.
Legally Speaking, a program that deals with legal issues and questions we face as citizens of this amazing country, Nigeria. Legally Speaking. Join us every
Friday from 5 p.m. to 6 p.m.
for Legally Speaking.
Good evening, welcome to Legally Speaking on Planet Radio 101.1 FM and Spectrum TV on Star Times and other free-to-air stations. My name is Anthony, a Bukami legal practitioner with Law Partners and Associates, and this evening we'll be treating you to discuss on post-election discourse, particularly zeroing in on election petitions, as the panel are set to begin activities. I have with me in the studio today to discuss this and other issues that might crop up. Ekemini Udum is equally a legal practitioner. He is with Justice Chambers, he's a principal partner with Justice Chambers, and he writes well, so it's an author too. Ekemini, welcome to the show.
Thank you very much, Tony. It's a pleasure to be here.
All right, Ekemini, we go straight to Osun State. I think there has been a judgment of the Court of Appeal with regards to the election petition of that case, Adeleke, right? Recall that the election petition tribunal had ousted the incumbent, I think we are right to call him the incumbent governor, and now the Court of Appeal has set it aside. At least that's what we hear. So yes. I know why I'm saying at least that's what we hear, because there have been conflicting reports on that.
Yes, there have been conflicting reports.
All right, let's hear what you have.
When we're talking about conflicting reports, you know, we're sadly in a situation where you have to verify whatever you read as being the breaking news. You verify it from more than one source and so on, and that's for me is quite worrisome. So Adeleke, congratulations to him. We understand that he has won today at the Court of Appeal. Remember that the Election Petition Tribunal sitting in Osogbo, Osun State, in a split decision of 1:2, made a declaration that Adeleke was not validly elected as governor of Osun State, that there was overvoting in a particular area. And a lot of people were questioning, so what then happened to the beavers? Because in Osun State, beavers had been used. And a lot of issues were asked, arose as a result of what is the efficacy of the beavers. Adeleke expectedly went to the Court of Appeal, and the Court of Appeal has this morning ruled clearly that Adeleke had won the election, and that the trial court, that is the tribunal, was not correct, was in error to have set aside the election of Adeleke. And that is in line with the dissenting judgment of the tribunal. Remember that one of the judges at the tribunal had clearly taken a position that based on the evidence presented to the tribunal, Adeleke won that election. But in law, a dissenting judgment takes the back seat. When two members of the panel have said that this is the position of the court, and one says, I don't agree, the person that doesn't agree takes the back seat. The people that have agreed, the two judges that have said this is the position of the court, that takes the day. And it was for that reason that Adeleke, the election was nullified by the tribunal. But luckily for him,
Adeleke's win was nullified, not the election itself.
Adeleke's win, yes, was nullified, not the election generally. But luckily for him today, the Court of Appeal has said, yes, you were validly elected. And his next prayer now is what the Supreme Court will say, because I'm very sure that the other man will go to the Supreme Court.
Of course, everybody will have to go to the Supreme Court. Now, don't forget, Adeleke is the dancing governor, and there was so much joy when he came in, and being from the opposition, at least this time, coming from the opposition, a lot of people thought the beavers have really worked for us. It was a sad thing when the Petition, Election Petition Tribunal said, no, you were too... You recall that, I think part of the warnings of the judgment sounded like a music.
Sounded like some stanzas from a popular novel or something.
No, a popular musician.
Okay.
He was too quick to celebrate his win when he should have waited first.
And a lot of people criticized that.
Criticized that. He tended to show that there must have been some form of bias by the judicial officer, right? And that was the presiding justice. I think it's important that we explain that at the Election Petition Tribunal, they sit almost like a court of appeal. They have three judges sitting at once, and subsequently, I think 5 in the Court of Appeal.
Yes, Court of Appeal 5, because it's a constitutional matter.
The Supreme Court then takes 7.
7.
So people will also be interested in knowing what happens, which we have explained, that after now you can go to the Court of Appeal. Don't forget, it's now 1-1. Somebody has to win. The Supreme Court, funny enough, the Supreme Court might go back and say, all right, the Election Petition Tribunal was right. That's the crisis we have in Nigeria. There's no consistency in the reasonings of the courts.
But the Supreme Court can also go to say the Election Petition Tribunal was wrong, so we affirm the judgment of the Court of Appeal. But I agree with you on your concern, which is also my concern. The Nigerian electoral system is such that even at the polling unit, the election is seen to be inchoate until people go to the court to test it and then finally hear from the court. I said this morning in a sister media house that, see, we need to, get certain things right so that by the time the electorate decide at the polling unit, that becomes the decision, final decision, to the extent that it is watertight, that no one will even bother to go to court, or there will be no irregularities, no one will go to court, so that people will be elected based on the popularity of the people, based on what the people of Nigeria want. But as it is now, it is the Supreme Court that has to decide for the Osun State people.
You see, unfortunately, that's what I'll be saying almost every other time I'm on TV or radio. I keep wondering, why must the courts decide for the people? It's a democracy. Democracy ought to be ruling by numbers. Whoever has the majority vote should be the person that we have decided will be our president, our governor, our House of Assembly, House of Reps members. But as it appears in Nigeria, the elections are decided by the court. So it's actually the court who decides who will superintend over our affairs. It's no longer democracy, as I feel. It's rather, do we call it courtocracy? Because in the end, it doesn't matter whatever you do in the field and the numbers you're bringing down. Whatever the court will say at the end will be the final option that you take.
Yeah, but you can't also blame the court. The court is doing its own responsibility. a creation of a constitution where the constitution, saddles with the courts with the responsibility to intervene between two, in quote, warring parties. This side is saying, I'm not in agreement with it. So the court then comes in and then decides. What I rather think is a problem is the fact that as a country, we have failed to have transparent elections. Now, remember what happened in Abia State? But for the intervention of, I don't know, maybe the creator, in favor of the winner. Something magical was about happening in that state. Someone was supposed to use maybe the election from one local government, Obingwa or something, to swallow every other local government in that state and then become the governor. But for the insistence of the electoral officer that was in charge of, the collation, that is the professor, the vice chancellor for Futu. So if not the intervention of that lady, something would have happened which would have been against the will of the people. And it is as a result of things like these that matters will continue to go to court until we have transparent election. But I get bothered when matters keep going to court because we've not done the right things and the courts keep deciding for us. Most times, courts decide based on evidence presented, sometimes even on technicality. So if something is not filed within time, or as people are going to election petition tribunal, something as simple as non-filing of the pre-trial form is enough to dismiss a petition, and the law allows it. And when that is done, the man whose election is questioned, is queried, becomes the person, leading the people in a political office. So the earlier we correct these as a people and begin to have free and fair election, I think the better for this country.
Okay, I also want to observe that over time we have made election of officers into seats of government so prominent in Nigeria that it has swallowed up everything. Now let's look at the CBN policy. A lot of people say the policy came out timeously just to ensure that the election is done free and fair, votes are not bought, but it crippled the economy, right? Now, 30 days, about 2 months ago, we've had several judicial officers inaugurated into election petition tribunals. I was in court recently and the judge said, I want to tidy up this case because I'm going for the tribunal. And when this court leaves for tribunal, 6 months is the minimum time you would expect them to come back. Now, when a court is shut down for 6 months because there was an election in Nigeria, ordinary citizens don't have a say as to what affects them because we want to answer the election issue. Well, answer the leadership question. Now, if that's the case, is there any other way? Is it done the same way in the United States of America or Britain where we borrowed this democracy from? I doubt if it's so.
It's also.
Yeah, because I would have thought a regular court could continue to sit and hear election petition tribunals, election petition alongside. The way you now have to invest so much in setting up these tribunals, such that every state will have at least 3 members sitting in the tribunal.
Well, it's a very sad narrative, and for us that are practitioners, we understand the direct impact. It's a disruption for me. For instance, I have cases in 4 divisions of the court within our jurisdiction that the judges are going on tribunal assignment. And the matters I have in those courts will not be heard in the next 6 months. And these are human beings. When they go sit for 6 months, they need to come back, take rest for at least 1 month. Remember that we're also going to go on a legal vacation by August. The distance between now and August is just 4 months. And therefore, it's almost like the whole year, the whole legal year, has ended in some courts as a result of the assignment, national assignment of these judges. It's a disruption that we need to correct as a people. I have said that should we continue this way, we are not developing this.
Yeah, for those of us around TV, I think the shot there was the dancing governor celebrating his 3rd victory, second in 3 victories. Okay, that's him dancing now.
No, we're definitely going to see.
It's a roller coaster.
Yes.
You win the election, the next thing you're told you're out, and then you go to Court of Appeal and you start dancing again. Meanwhile, as you're dancing, your mind is on the Supreme Court.
Exactly.
What's going to happen at the Supreme Court? Because it can be very fatal.
It can be very fatal.
All right, the phone lines will be opened about now, right? Or are we opening in 10 minutes time? I think the phone lines will be open in 10 minutes time. So we'll read out the numbers to you. The numbers you will have to call will be 090-222-31011. That number is again 090-222-31011. The alternative number that you will have to call will be 070-454-17707. I repeat that alternative number, 070-454-17707. So we are discussing election petition matters and tribunals. Ekemini, let's get back to what an election petition tribunal is indeed and in fact. What must a litigant do? Now, I understand first that you must file a petition within 21 days. And if you don't file it within 21 days, you forget it. Whether or not you have won the election or you could win at the tribunal, it is statute bad. Now, subsequently, there are things that we should look out for. Hello.
Hello.
Yes, go on, sir. I think we can start the phone line stuff.
So, there are things required of the petitioner in an election petition, and this is also a requirement of law. So you don't go outside the requirement of law to bring extraneous matters. It is a kind of litigation that is called sui generis in law, and that means that you must work within its own circumference. And the grounds for election petition are basically three now. In section 134 of the 2022 Electoral Act. Before now there were 4 grounds, but now there are 3 grounds. Now the grounds are: 1, that a person whose election is questioned was at the time of the election not qualified to contest the election. If you see Obi's petition, Obi is saying that the president-elect was not qualified at the time of the election to contest because he was convicted. That's what Obi is saying. The second ground is that the election was invalid by reason of corrupt practices or non-compliance with the provisions of the Electoral Act. This is the ground that most petitioners rely on, because this ground is capable of containing a lot of things. Violence at polling stations, irregularities that are very clear to see. Vote buying, if you can prove that, and a whole lot of other things.
I understand that's the most difficult ground to prove.
Well, but this is the ground that is mostly used.
Mostly used, but mostly very difficult to prove.
Well, it's the most employed ground. The third ground is that the respondent was not duly elected by majority of lawful votes cast at the election. And this one is very simple. If
that's the Adeleke ground, I believe.
Yes, and this has to do mostly with overvoting. If, for instance, this person was declared with a certain number, and then you're able to prove to the tribunal that there was overvoting, or the accreditation that was done is not the same, does not tally with the result as announced, then you can easily upturn an election. So these are the 3 grounds that you can take a petition to the tribunal. You don't go outside this. Whatever you want to say in the petition has to be woven around these 3 grounds. Remember, in the previous Electoral Act, there was a 4th ground, and that 4th ground was that the person was unlawfully excluded from the election, that the petitioner was unlawfully excluded. But now, in the wisdom of the makers of the 2022 Electoral Act, unlawful exclusion is no more a ground. And that's why, after the first election, the presidential election, you had the gentleman from Kano State, the Kwankwasiya movement man.
Kwankwaso.
Yes, Kwankwaso. He said that his name, his logo, the logo of his political party was excluded from the ballot paper. And I was just saying, if he is planning to take this as a ground for election petition by the new Electoral Act, he may not be able to hang that complaint in any of these 3 grounds. So these are basically the grounds that anybody who wishes to contest an election will have to.
All right. So now, if we look at the previous ground that was excluded, I think it was basically something that could be sorted out at the party level. Remember, that's what a lot of people used to do. I was excluded from the primaries. I ought to have been the flag bearer, and they run it all the way. So it's a pre-election matter. It's usually a pre-election matter.
Well, I think
after the election, unlawful exclusion is usually difficult to find, because INEC now says it's a party that runs the election. Whatever happens, whoever is a flag bearer we will be told by the party, and that is covered largely by pre-election matters.
Well, I agree with you to a large extent, but also there are various stages of exclusion. Someone can be excluded by his political party. Someone can also have his name sent to INEC, and INEC, either by mistake or by mischief or by error, whichever one, omits the logo of your political party in the ballot paper. That's also one of the mischief that was intended to be cured by the inclusion of unlawful exclusion, because when you unlawfully exclude a party at the point of voting, the party faithful cannot vote. That was the kind of unlawful exclusion that the law was talking about. But now they say it's no more ground, and I see that as being worrisome, because if I am mischievous and I have INEC that is also ready to buy by mischief, all I need to do is to talk to whoever is doing the printing at INEC to exclude your political party from that ballot paper.
I doubt
if that is done.
I doubt if that will fly.
No, but if it is done, you now go to the tribunal.
If you read that law, it says unlawful. It used to be unlawful exclusion, right?
Yes.
Unlawful exclusion doesn't exist again. Before printing ballot papers, usually the parties are made to see, right?
Yes.
They have a committee who looks at it. Okay, this is the logo of my party, and if you see, I doubt if that will happen, because that will be outright disenfranchising.
It can be. Don't forget the country that you are in.
I remember the country.
Okay, you remember the country.
Nigeria.
So that exclusion can be done few hours to the election, and then you go. You cannot cast your vote even for yourself. No, you now want to go to
few hours to election. Don't forget these are security printings.
I know.
And they are not done within hours.
Security is manned by Nigerian citizens.
Of course.
So it's not forensic security.
Let's go to these other.
So if you ask me, that ground was equally very important to check mischief. Now, if someone's political party is excluded, he can't even go to the tribunal, because he lacks the local standing now to even go and complain at the tribunal. Now, he cannot also go to the regular court, because you can only complain against what happened at the election petition tribunal.
Maybe we have observed that over the years we've hardly had issues of unlawful exclusion. So the framers of the law are probably not concerned about what usually doesn't happen.
Well, maybe we should have had surplus for the sake of any mischief.
The general grounds has always been that I did not have irregularities, which is what everybody goes out for. Irregularities, overvoting, thuggery, and the rest of them. But most times you have difficulties proving this, because election petition cases are proven beyond reasonable doubt. They are like criminal matters. The standards and stakes are high. So if you come to say there were irregularities, okay, let's take for instance the national election now, and you want to show that there was massive thuggery, and you're showing that in probably Lagos as it has appeared now, Lagos and some states in the east, would that be a viable ground?
Well, it will not be, because when you look at Nigeria, for the purpose of election, Nigeria is 37 states, because the FCT is interpreted to be a state. If you look at section 299 of the Constitution, you see that the FCT is given the status of a state, and that's why they have
purposes of the elections, especially for purposes of election. I have heard the argument that you must win in addition to the FCT. I disagree with that argument. FCT, if you interpret FCT to be a state, it therefore means that if you have 2/3 majority in 24 states of the federation, including the FCT as a state, then you have won that election. So now, you have to prove irregularities. Polling units. Don't hang it there. Don't hang it there.
Okay.
Because you seem to be approving the position, the theory that you mustn't lose the FCT. And I don't think that's the position of
you can lose the FCT and still win, and still be declared as the winner of it. That's the point I'm making.
Okay,
that's why
I knew that you made that very clear.
Okay, that's where I said that for purpose of election, count the FCT as a state. An FCT is a state. It has a governor with the
Even though it's
nomenclature
called, even
of
though
a
it's
minister.
called a minister. Right?
Yes, and it has its own administration. Local governments are there. National Assembly makes law for them. So it's a state. Now, so you don't need to win Abuja before you can be declared the winner of a presidential election.
You don't need to have 20%.
You don't need to. If you have in other states of the federation and the people of Abuja, they don't like your face, the tribal marks, or you don't have a beautiful face, they can still keep their votes and you still become the president of Nigeria.
All right, gentlemen, the phone lines are now open, so you can call the number 090-222-31011. Repeat that number, 090-222-31011. The alternative number to call will be 070-454-17707. I repeat that number, 070-454-17707. All right, so yeah, you were saying.
Yeah, so when you talk about proving irregularities at the election, it's a Herculean task for the petitioner. So much. Because the law requires that you must prove substantial irregularities. So, if there are 100 polling units and you prove 20, it is not enough to nullify an election. You've not started. You need to prove further to show that there were irregularities polling unit by polling unit, because you are challenging results. And results are from polling units.
Let's take this caller. Hello, you're on to Legally Speaking. Hello. Well, please, when you call, stick on the line, listen to us, and hear if we are talking to you. Or you just, hello? Please, we can't hear you. I guess we've lost that call. Yes.
Okay, so the law requires that you prove it polling unit by polling unit, and it's not an easy task. And you have to prove this within 180 days. So, for instance, Obi, Atiku Abubakar, and the other gentlemen that have gone to court to challenge the declaration of Asiwaju Bola Ahmed Tinubu, they have a very Herculean task.
Yes.
If their petition is hanging on irregularities, you must prove the irregularities. If you talk about thuggery, for instance, you talk about a lot of other criminal things. Remember, election petition is a civil petition. But once you mention issues of crime and criminality, the law requires that you prove those points beyond reasonable doubt.
And by proving the points beyond reasonable doubt, you might need to have polling agents on all. Hello, this is Legally Speaking.
Hello, I can hear you loud and clear.
Very well, sir. Your name and where you're calling from?
I'm calling you from Port Harcourt.
Welcome, sir.
Mr. Ifeanyi from Port Harcourt.
Ifeanyi, welcome to the show.
I greet you, and I greet your guest in the studio.
Yes, that's a case.
Please, I overheard your guest saying that a presidential candidate can be declared without capturing the FCT, without capturing the two-thirds in the FCT. That FCT is hereby determined to be a state in electoral matter. I want you to throw more light on that, please. That is my area of concentration.
Okay.
Thank you.
All right, fine. Thank you very much. Okay, I think that's I guess a lot of people will be interested in that position.
You've heard the argument making the rounds that, and it happened even before the election, that the Constitution says, I think section 182 or so, says for someone to qualify to be declared as winner of a presidential election, the person must win 2/3.
The majority of
must have at least 2/3 of votes cast in 2/3 of the states in the federation and the FCT. There is that provision in the Constitution and the FCT. Now, people have interpreted this to mean that you must win in the FCT, that even if you win in 36 states of the federation and you don't win in the FCT, it means that you are not qualified to be declared as a winner. There is another side of that argument that says that the FCT should be taken as one of the states that the Constitution is talking about you winning, having 2/3 majority, 2/3 of votes, valid votes cast. And I buy that side of the argument. There is something called, there are rules of interpretation. When you talk about a jus dem generis, you look at when the Constitution is mentioning states, the FCT is a state. It has a minister who is a governor of that state. And therefore, the law could not have intended that victory in all states of the Federation without the FCT disqualifies you from being declared as a winner. So that's why I'm saying, if you take the FCT to be a state, now having 37 states of the Federation, if you have 2/3 of that, you can rightly be declared the winner of that election.
Hello. Hello. All right, I think we lost that call. So, you see, a lot of people have really mistaken the issues of definition of the FCT as is in the Constitution. The Constitution says, for the purposes of election, the FCT shall be regarded as a state. Hello, good evening. Welcome to the show.
Yes, please, sir. Yes, I'm calling from Crossriver State, Akamba.
Okay. Go on, sir.
So I want to know what is the situation between the presidential election based on court issue.
Can you come again?
I want to know, sir, the issue between the presidential election based on court issue. What is the decision?
Well, I don't know if you understand the question, but I think he's trying to have an idea if there's been petitions and if there's an update on the petition. Anyway, that's what we are discussing right now. We are looking at the timeline for filing petitions in court against election results and what we should be looking out for in terms of the petitions that have been filed. What are the expectations of the law? What should you show when you bring your petition? That's what we are doing right now. So just keep listening to us. You have clarity on some of these issues. So we're going back to the issue of the FCT being a state and not being a state. I'm not sure the Constitution, the makers of the Constitution, in any way intended to make a super state out of the FCT. If you have concentration. Hello.
Good evening.
Good evening. You're on to Legally Speaking.
Yeah, my name is John. I'm calling from your place. I want to help my brother in the spirit. That section is section 134 of the Constitution.
Okay.
That election to the office of the president. And it's very clear. It is not ambiguous. Very, very clear.
Can you read the interpretation section? Can you read the interpretation section of the Constitution as to the status of the FCT?
Section 134, subsection 2.
What does it say?
It's about having the highest number of vote cast and winning not less than 1/4 of vote cast at the election in each of at least 2/3 of all the states in the Federation and the Federal Capital Territory.
Now, when it says and, when it says and, does that and mean the Federal Capital Territory being one of the states that should be?
That is one of the states.
Exactly. If it is one of the states and you have 2/3.
All the states in the Federation and the Federal Capital Territory, meaning that Federal Capital Territory is a state.
Exactly. So if it's a state, you don't need to have a special status that when you don't win in the Federal Capital Territory, then you are not qualified. Right?
It does not come for. You only need to win the highest. What is considered in the Constitution of Nigeria is having the highest number of votes cast.
Exactly.
And having not less than 1/4 of that vote cast in at least 2/3 of the state.
Okay.
That is the provisions of the law.
So you don't need to win in the FCT before
you don't need to win the FCT.
Exactly.
Exactly.
So I think we are on the same page.
We're on the same page.
Thank you very much.
Are you a lawyer?
So, you see, some people try to whip up issues. I don't see why the framers of the Constitution will make a hard rule. If you come to the states and say, okay, in Akwa Ibom State, there are 30, 31 local government areas. So if you win to 10 and lose with you cannot be governor of the state. No matter how many votes you've had to win, you know, how widespread you are. Because the issue is about the spread of the popularity of the candidate. So a candidate will not just go win 5 local governments in Borno and return 250 million votes.
Now,
and not have votes across the rest of the country. They say, no, let there be a spread. So when you are working, you work towards spreading your popularity to other regions of Nigeria. So you won't just sit in one corner and say, well, we are the largest population, so let's concentrate and pick everything here, and we care less about the other. If not, you come in and be a regional president.
So when you look at someone like His Excellency Kwankwaso, his Kwankwasia movement concentrated in Kano State,
yes,
which is very popular there, and he has won even the the governorship election.
Yeah.
The constitution has, clearly stated that for Kwankwaso to win election, he needs to extend the Kwankwasia movement and be able to spread it across the Federation of Nigeria, to be able to have everybody now voting for him, and not only making him to be a sectional president, because he is supposed to be president for all. Now let me add this. If you look at section 299 of the Constitution, it says, the provisions of this Constitution shall apply to the Federal Capital Territory, Abuja, as if it were one of the states of the Federation. So that's the Constitution, which has even given further interpretation, to the status of the Federal Capital Territory. And therefore, the argument that you must win Abuja couldn't have been the intendment of the makers of the Constitution. Because what does it take? All what it takes is for someone to make sure that there's no election in the FCT. So that even if you win in all the 36 states of the Federation, you cannot be declared winner. And that could not have been the intendment of the makers of the Constitution.
Exactly. So one must understand that the purpose of Election Petition Tribunal is not to create an electoral clock in the wheels of politicking. That's the way Nigerians see it. So they bring all manners of things to the Election Petition table, presuming that whatever I couldn't do at the pre-election tribunal can be done at the election tribunal. All right.
Well, it's dangerous to go that way, because if you see the proceedings at the Election Petition Tribunal, as a matter of fact, some of our colleagues don't like doing election matters because it saps your time. It takes your time. It doesn't allow you to do other cases, because your cases are adjourned from day to day. The judges sit every day.
Every night.
In fact, there are sometimes you come back from the tribunal 11 p.m.
and you still have a cross-examination the
following
morning.
By 8. Okay. Now it gets to a point at the Election Petition Tribunal where lawyers are given 5 minutes to cross-examine, as simple, as short as that, and you're given 2 minutes for re-examination, if any. And you know that in the regular court, it's very rare to just have 5 minutes only for cross-examination, except maybe the lawyer just has one question and then says, my lord, that's all. But the courts will not limit you to 5 minutes of cross-examination. But in election petition, it gets to that point that lawyers are given 5 minutes and 3 minutes to cross-examine and so on. So that means that it's almost like a crash program. It means also that there's no room for frivolities. So if you are filing things and just bringing everything that you think of from the village to the city center and you want to heap it in your petition, you are not doing justice to your petition. Petition should be as brief as possible and should hit straight at the issues in contention. If you are saying there was overvoting, hit straight at overvoting.
And concentrate all your resources.
Concentrate there.
Overvoting. Bring out the INEC is supposed to give you a certified copy of all the electoral materials that were used. You bring them out and compare them with the documents that you think INEC has. If the voting strength of a particular location was 200 and INEC posted 500 voters, you just concentrate on those ones, leave the rest of them.
That's it.
And pray, just pray that you have majority of that complaint spread across.
Yes.
So it wouldn't just be one location or two locations.
Yes.
Because if it is one location or two locations, they will exclude those locations and the numbers are still stacking against you. You know?
So once you're able to reduce the numbers through very careful proof at the tribunal, it's almost like maths. There's a lot of maths and further maths in election petition. You're able to prune it down one by one. Next thing, the tribunal has no option than to declare what you wanted. And so in cross-examination, it is often said, do not ask a question to which you do not already know the answer. In election petition, don't go filing for things that you don't know how the outcome is going to be. If you are asking for the setting aside of an election because of overvoting, go straight to that. If you are saying that this person was not qualified to have even stood election in the first place, then go straight to that. Are you saying that you don't have the basic educational qualification or that he forged? If he forged, you need to go to the issuing authority to get a letter.
Not even a letter, they call it like police reports, not just a letter, that this person was investigated, and this is what we've come up with.
Well, the nailer is if someone says a community did not go to the faculty of law, you go to my university, and you get it from the registrar that I did not attend that faculty, certified true copy. When you bring that in, then you have succeeded in proving that ground, and you can easily set aside, you know, that very election. So it's not an opportunity for frivolities. It's a matter of getting straight to the point. That court has no time. That court gets overburdened by the volume of petitions. In Akwa Ibom, for instance, after the presidential election, the first election that took place, I understand that 16 petitions have been received. I'm surprised that it's that much. That means in the State House of Assembly election, the governorship election, we are sure going to have more petitions arising. And therefore, those courts are very busy. They don't have time for frivolities. Go straight to the point. If you don't have something to take to the tribunal, it is not compulsory that you must go to the tribunal.
All right, the numbers to call again are 090-222-31011. The alternative number is 070-454-17707. So, generally speaking, people tend to encourage their fans, their supporters, that they still hope, when obviously they know there's no hope. And a lot of people are more comfortable having hope that they filed a petition. Some petitions are doomed from the point of filing.
Yeah, some petitions are
Hello.
doomed.
Good evening, gentlemen.
Good evening. Welcome to the show.
Matthew calling from Calabar. Yes, sir. I want to find out the appeal court has affirmed the election of Adeleke of Osun State. Please, I want to know the ground of that affirmation of the appeal.
All right. Thank you very much. We will not try. We will not try to hurry into telling you the grounds, okay? Because the result just came out this afternoon. We'll have to study the report of the judgment of the Court of Appeal and be sure of exactly the position, right? What we passed along was the news that the Court of Appeal has affirmed the election of Adeleke without telling you that this is the grounds they use. We were careful not to say so. A lot of things you're reading on social media are really very, very worrisome. If you recall that earlier in the day, there were some reports stating that the Court of Appeal has affirmed the position of the Election Petition Tribunal sacking. Then all of a sudden we have this other news that said that this is actually the position of the Court of Appeal. Some people just stay in the courtroom and be sending out information until you hear the resolution of the court. That judgment is not yours. So people just want to be the first to say. Hello, good evening. Welcome to the show. This is Legally Speaking.
My name is Progress, and I'm calling from Uyo.
Progress from Uyo. Go on, sir.
On the matter of the law that provided that a candidate must win the FCT, I think the and for the FCT applies that the must individually applies to the other factors and also applies to the FCT as an individual factor, so that if the person wins in the rest, the person has to win in FCT also. Not that FCT is one of the sideline factor, like it's not a determining factor. FCT is a determining factor.
Okay, that's a good opinion. Thank you very much, sir.
But let me read again. Section 299 offers more explanation as to the status of the FCT. 299 of the Constitution. It says, the provisions of this Constitution shall apply to the Federal Capital Territory, Abuja, as if it were one of the states of the Federation. So it makes it clear. Abuja, FCT is one of the states.
Now, I think what the Constitution was trying to say is this. If at the end of the day you count your state and you don't have up to 2/3 of the state, but you have FCT, you count it along, it becomes one of the two-third states.
Of course.
As a way, using the FCC as a way to support your position
Yes.
rather than to derogate from it.
Yeah.
So
Now,
when people want to see derogating, okay, what did the court say or what did the law say subsequent to that provision? Did he say, yes, this is legally speaking.
Nicholas calling from Calabar.
Nicholas from Calabar, welcome to the show.
Thank you. Please, my own is a question.
Go on, sir.
I want to ask, why is it that the tribunal, the election tribunal or the Supreme Court upturned the election of governors, but it has never happened in Nigeria to upturn the election of president?
Okay.
Why?
All right. Yeah, you want to take that again?
Well, I think the simple answer is that so far nobody has been able to convince the Supreme Court or the Court of Appeal.
The Supreme Court is...
No, Court of Appeal. It starts from the Court of Appeal,
Okay.
sitting as election tribunal for the presidential election. So I think it is because so far nobody has been able to convince these two courts that a election was marred with irregularities or
Widespread
irregularities, or that the person that was declared a winner was not qualified. For instance, and I think there's nothing that stops the Supreme Court from doing the needful once the facts, the allegations have been clearly proved. For instance, if it is said that someone was not qualified to have contested that election in the first place, which is a ground very easy to prove if you have all the facts, maybe the person has never gone to school, or maybe the person is not up to the age for one to contest for the office of president, but he went on to contest using falsified age, and somebody has gone to the hospital where he was born to bring out the certificate of birth that was written by a matron, a white matron, handwritten, and brings it up. It's very easy to set aside an election, based on that. So I don't think that the courts are not willing, but I think that so far no one has been able to prove it very clearly. If anybody does that, there's nothing that stops the court from doing the needful.
And you must know one thing. The court is not in a hurry to just upset the polity. So when you set aside a presidential election that was largely regular, because the key word there is largely regular, not largely, well, largely regular too would be part of it. The court wants to be sure that when you're setting aside a presidential election, that it deserved it, right? And not just that there were some irregularities. There will be irregularities. Like in this particular election, a lot of irregularities in Lagos, which we understand. But it is spread.
Well,
it wasn't widespread.
Some other person would tell you that it was widespread, but it is left to be proved in court.
Yes.
Now, this is what I think.
Let's take this last caller. Okay, sir.
Yeah, I want to ask, Peter B, one of the ground of the...
We are not hearing you, sir. Can you be...
Matthew calling back, sir.
I know.
One of the ground of Peter B in the tribunal is that Adeleke was convicted in London. And my question is, what does London conviction have to do with election in Nigeria?
Okay.
That's just my question.
Oh, that's your concern. That's not your question. Because we are here with you in Nigeria. We are not in London. We are not in the US. So whatever it had to do with it. But I think if I must assist you very briefly. That was the last call, please. Hello.
Hello. Good evening, sir.
Good evening.
Yeah, I'm calling from Edo State. This is Mr. Carlos from Edo State.
Edo State. Go on, sir.
Yeah, yes, sir. I'm listening to your conversation regarding the election issues as regards the 25th of December.
Okay.
So what I'm trying to say is that I think, I'm not a lawyer, but I think in the Electoral Act, there is a place that says that that for anyone contesting for the office of the president must win 24 states. Otherwise, I don't know the way they put it.
Okay.
That means 24 states and 25% of the 24 states of the federal of the whole country. Then an FCT an FCT. I think that is how the Electoral Act puts it.
Yes.
That means the person that has been said to win the presidential election more inclusively win FCT.
Okay.
So I don't know, because based on your conversation.
Okay, let me assist you because of time. Let me assist you. You see, the Electoral Act is subject to the Constitution. Yes, the Electoral Act is subject to the Constitution. So the provisions of the Electoral Act, no matter how misconceived it is, cannot override the provisions of the Constitution. So if it comes up before the Electoral Tribunal, they'll have to compare it vis-a-vis the Constitution of the Federal Republic of Nigeria. We're out of time. There's so much to talk about. But
let me just add something. Sorry.
As your last word, please.
Yes. There is confusion in that section. We must admit that, and therefore, the National Assembly should amend that section in the next round of election. Constitutional amendment to say 2/3 majority in all the states of the Federation. Full stop. For the purpose of this section, the FCT shall be seen to be a state, something like that.
I think that will put a final clarity.
It will.
All right, gentlemen, and that's how the size of Legally Speaking for the week is. I hope you enjoyed yourself, and we look forward to seeing you. I've been with the Keminodum, a very, very faithful and heavenly friend of mine. My name is Anthony Ebuk, I believe. Until same time next week when we meet again, everything you do will be legal.
Which is the only one allowed by grossly abused. Our governors have to share police powers with the president as stipulated by the Constitution. We do not have a federal government police force. We have the Nigerian police force, which shall be administered, organized, and supervised by the Nigerian police force.
No, my lord, I want to say something. I want to say something here. Perhaps it might also enlarge the scope of people who should be invited here for examination. My lord, if we cannot find those who literally murdered Abiola, who are those people who could be said to be the beneficiaries of the death of Abiola?
Rogers has linked you with some of the killings he did.
He never did.
He linked you with the attempted murder of Hebrew.
He did not.
My lord, the Matters Council is leading the evidence in our matters.
Is this an adversary proceeding?
It's not, my lord, but we can't be talking about cases which are in court.
Is this an adversary proceeding?
It's not, my lord. These cases are in court, my lord. I'm just reminding your lordship.
My lord, sorry, my lord, I think I'll be in cross-examination.
Legally Speaking, a program that deals with legal issues and questions we face as citizens of this amazing country, Nigeria. Legally Speaking. Join us every
Friday from 5 p.m. to 6 p.m.
for Legally Speaking.
Spectrum TV, broadening your horizon.
Business exists only to meet the needs of the people, but there's an extra advantage if your product and services are pitched on a platform that gives you the added advantage over your competitors. For your desired return on investment and so much more, advertise on Spectrum Television, on StarTimes DTH Channel 421 and on free-to-air with a frequency of 12733. Spectrum Television, broadening your horizon.